to Legally Speaking. With me, Tarun Nangia. We commence our part 2 in our series where we talk about personal guarantors, personal insolvency, and the assets of personal guarantors, what happens to them. And we'll also talk about the judgments of the Ahmedabad Debt Recovery Tribunal and Lalit Kumar Jain versus Union of India 2021 case, because a lot of promoters are interested what is happening, specifically in the Ahmedabad DRT matter, what happens to the assets of the personal guarantor in case the debt has already been assigned. So we begin our discussion today. May I introduce you to my panel? I have with me Manmeet Singh. He's partner with Saraf and Partners. Manmeet joins us on the show for the first time. Welcome, and looking forward to some interesting interventions from you. I have with me Tahira Karanjawala from Karanjawala and Company. She's a familiar face. Shravan Shankar from Rao and Shankar. We practice at the Delhi High Court and the Supreme Court of India. Shravan, welcome once again. And let us start with our round of opening comments. May I request Tahira Karanjawala to lay the ground, following which we go to Manmeet for the introduction.
Thank you, Tarun. Tarun, I think that as far as the law on personal guarantors is concerned, it's now been quite, conclusively laid down in Lalit Kumar Jain that merely because the debt of the corporate debtor stands extinguished by the corporate insolvency process does not mean that the personal guarantors cannot be proceeded against by the creditors. And I mean, to the extent that the debt has not been recovered in the corporate insolvency resolution process. In fact, recently the judgment of Mahendra Kumar Jajodia has thrown up a new issue as to whether the personal guarantor can be the insolvency bankruptcy process against the personal guarantor can be invoked even without the CIRP pending against the corporate debtor. And there the insolvency against the bankruptcy against the personal guarantor can be initiated even without any CIRP pending against the corporate debtor. But this has been stayed by a judgment of the Supreme Court relying on a particular paragraph of Lalit Kumar Jain. So this is the only point I think that that stands which still needs to be resolved by the Supreme Court. But otherwise, it's quite clear that the forum for the resolution against the personal guarantor is also the NCLT, yes. And there is no bar as far as initiation of proceedings against personal guarantors is concerned. The question is only, can it be done without the pendency, without the CIRP against the corporate debtor already pending?
Okay, point well taken. I'll go to Manmeet Singh, partner, Saraf and Partners. Manmeet, in about 3 to 4 minutes, could you, in a sense, explain us this whole confusion that is arising? Promoters want to know, banks continue to go after personal guarantors. Where are we heading, say, because this Ahmedabad DRT judgment will go right up to Supreme Court. I mean, that's a foregone conclusion. In light of what happened in Lalit Kumar Jain, it is binding also. How does the Ahmedabad DRT judgment deal with it? Could you share all of this with us?
Sure. Thanks, Tarun. Thanks for having me on the show. I think there are two issues, and as Tahira pointed out, the first issue is, of course, arising out of the Ahmedabad judgment, DRT judgment. There, the key question was that if the debt stands extinguished or assigned, as the case was in the facts of that particular resolution plan, then and it does not stand in the books of the lenders anymore, then what are the lenders claiming against? I think that was a key issue, and that was answered by Ahmedabad DRT by saying that since the debt stands extinguished, since it has been assigned, since it doesn't stand in the books anymore, there is nothing that the lenders can claim against. After all, what they have to claim against a liability. If it is not standing in the books, then what are they claiming against under the personal guarantee for? However, I think the counter argument to that would be, and as you rightly said, this is a judgment which would travel all the way to Supreme Court. The counter argument to that would be that the guarantee had been invoked prior to approval of the resolution plan, and therefore a liability stood created, a guarantee which was in the nature of a contingent liability had devolved, had crystallized, and a liability stood created vis-a-vis the personal guarantor as well in the books of the bank. So notwithstanding the extinguishment or satisfaction of one liability, so long as there was a shortfall in the satisfaction of that liability and the bank did not recover its entire sum due, there was a liability which was vis-a-vis the personal guarantor which survived that assignment or extinguishment. Now, if one were to look at this logically, let us assume the plan had not been approved and the company had ended up in liquidation. Even post-liquidation and post-distribution of assets in liquidation, the liability in the bank's books would have stood extinguished. Now, can it be the proposition, and this is what would need to be tested, can it be the proposition that in such case as well, the liability of the personal guarantor would therefore come to an end merely on account of the liability of the corporate debtor, which is now in liquidation and has been fully liquidated, assets have been fully liquidated, liability vis-a-vis the corporate debtor is coming to an end. If that be the case, then we are looking at a proposition that a personal guarantee would not survive even the liquidation of the corporate debtor. I don't think that is the intention of the law. I don't think that is perhaps the correct position of law in my case. I think this Ahmedabad judgment, DRT judgment, is likely to be revisited and overturned in appellate proceedings.
Okay, you feel that the Ahmedabad DRT judgment will be revisited and overturned. I'll go to Shravan Shankar. Your inputs on this issue.
So Tarun, see, in most cases, the creditors have to take a haircut in the insolvency resolution process. And now when we go to the Lalit Kumar Jain judgment, it's very clear that you can go after the personal guarantors. However, in what order? Can you bypass the principal debtor and then go to the directly go on to the personal guarantor is the question in the Manoj Kumar Jajodia case right now. Tarun, see, the entire code is a self-contained code. The objective is for speedy recovery, protection in the interest of creditors, including stakeholders, and also to revive the company. All in this to increase the credit supply in the economy. That's the whole objective of the act. Now, if you look at the code facilitates, if you look at 179 clearly says that for firms and also individuals, DRT is the forum where you have to go. However, when you read 61 and 2, one says that when personal guarantors and corporate debtors are concerned, NCLT has exclusive jurisdiction. 61 clearly says that notwithstanding anything, while there is an application pending for corporate resolution process against a corporate debtor, there only an application for a personal guarantor can come in play. To my reading, it seems like you can only go after the personal guarantors only when there is a pending application to go after the corporate debtors. However, the flip side is this will be puncturing the entire concept of corporate wheel. So this is something the Supreme Court perhaps has to look into and balance.
Thank you for that opening comment. We will take a short break and we'll be right back. Welcome back. Just before the break, we had Shravan Shankar giving his introductory opinion on this topic involving personal guarantors and their assets under IBC. I'll go to Tahira. Tahira, a lot of promoters are looking at this issue very closely because we see the immense number of cases now under IBC. Recently, a clutch of builders have also declared bankruptcy and a lot of assets are involved. What are the worries from the business perspective and what are the worries from the bank's perspective? Can you share that with us? Because on the one side, it is being said that you are forfeiting the bank's right to go after, in a sense, the personal guarantor, absolving him that once the debt has been assigned, you can't go after him, is what you're saying. On the other hand, the promoters are saying that once the debt has been assigned and somebody has bid for the company, why should they go after us? Say simply in plain speak, could you share the kind of issues that need to be highlighted before we come to any decision or conclusion on this?
Thanks, Tarun. So yes, naturally, of course, because often you find that the personal guarantors of the corporate debtors are the promoters concerned, and there's a legitimate argument to be made there that if the entire corporate insolvency process is ongoing and there has been a full-fledged bid. Agitate the issue with personal guarantors. And I think behind those two processes, because I feel that if you intertwine the proceedings against the personal guarantor along with the corporate insolvency process itself, then this could resolve some of the processes, and there could be woven into the resolution plan itself the payments that need to be made maybe by the personal guarantor in the particular case, so that you can have one unified resolution of the process. So I think this, this is actually one way of resolving the issue which the government had intended when it brought in provisions to unify the resolution processes against the personal guarantors as well as the corporate debtor. Because while yes, there is a legitimate argument to be made vis-a-vis that promoters should not have to the entire process should not be revisited again, but at the same time they had taken full guarantees, and these are public money. Often these are sort of public sector banks. So I think unifying the process is probably the answer.
Okay, point well taken. I'll go to Manmeet Singh, partner Saraf and Partners. Manmeet, if you could flag off 4 or 5 points that arise out of both Lalit Kumar Jain versus Union of India and the Ahmedabad DRT judgment, which in your view as a practitioner of law need clarity.
So I think, first of all, with respect to Ahmedabad judgment, the key question is, as you identified and as was stated earlier, that where the debt has been assigned or settled in entirety, then does any claim survive on the personal guarantee for the banks to collect at all? The second issue will be, which has been argued in the Ahmedabad DRT judgment, is that there is no right of subrogation which now remains.
Okay.
And one of the considerations for extending a personal guarantee by the promoter was the right of subrogation vis-a-vis the corporate debtor. Now, all resolution plans provide that the right of subrogation shall stand extinguished, and that has also been upheld by Supreme Court, that there can be extinguishment of right of subrogation. Now, if that be the case, then does that amount to failure of consideration, or at least part thereof, which was there at the time of extension of corporate or at the time of extension of personal guarantee? After all, when the personal guarantee was extended, it was on the belief that if it had to be paid, then the guarantor would have a right of recourse to the corporate debtor. In this case, once that right of recourse is gone, would a personal guarantee still survive? So I think those are a couple of key questions which will need to be settled along the way as in appellate proceedings in the Ahmedabad DRT matter. As far as the other issue is concerned, I think the key issue is that there is, of course, we all know a lag between the time taken for admission of insolvency proceedings when it comes to admission. Now, given that lag, should the bank be forced to go to DRT? I don't think it is the case where the bank is only looking to go after the promoter under the personal guarantee, but not looking to go after the corporate debtor. I think both happen more or less together. There may be some lag there, but both happen more or less together. Given that, should the bank be forced to go to DRT to initiate proceedings against the personal guarantor, or should 61(1) be read to say that the jurisdiction would lie with NCLT as well? On account of 179, as of now, to me, it appears that perhaps the jurisdiction is not there with NCLT at the time when no proceedings have been initiated against the corporate debtor. But this is something that the government can clarify along the way. Perhaps we don't need to see an adjudication on this. Government can come in and clarify this.
Okay, point well taken. I'll go to Shravant Shankar. Shravant, in about 4 to 5 points, highlight the issues that worry you and that are raised, and in your view need clarification from the point of the promoters.
Tarun, principally speaking, the entire idea of speedy resolution and providing a single platform for the entire debts to be cleared will go off track if multiple forums come in play. Yes. And also when you have to go, if my place of business in Delhi and the personal guarantor resides in, say, Gujarat, and you have multi-fora litigation happening, that is what they wanted to avoid. The whole idea was that. And in fact, if you look at what is very interesting here is the interplay between the Contract Act and also the insolvency process. That is, if you read section 128 of the Contract Act, it provides that there is coextensive liability between the principal debtor and the surety. In fact, I remember there's a 2004 judgment of the Supreme Court which says that you can go after the surety if you show reasons for not going against the principal. So this is something, see, because IBC after all is a self-contained court. Do we have to stick to the precedents under the Contract Act is what the Supreme Court needs to examine. So the DRT, Ahmedabad DRT issue where the debt stands assigned, what is the liability of the personal guarantors, and where we are in the Manoj Kumar Jajodia matter, where you have bypassed the principal debtor to directly go to the promoters. So they are the real people who own the company, who promote the company. So perhaps it would seem more threatening to the promoters that you come after the promoter even before you test your waters on the original corporate debtor.
Okay, point well taken. I'll go to Tahira Karanjawala from Karanjawala and Company. Tahira, two things. The number of insolvency cases now is ballooning. We're seeing many admissions in the past 2 weeks itself. In many cases, the condition of the companies was weak, and it could be the case that banks have gone after the personal guarantees have been invoked of the promoters. And now they will try to take shield in the light of the Ahmedabad DRT order. Do you think that somehow this should be escalated to Supreme Court the quickest? Because otherwise this will have impact on a lot of litigation that is happening in the country. What needs to happen? Where do we go from here?
I think this, will, as Manmeet earlier said, that I think this position will get reconsidered eventually, maybe not immediately, but eventually, in light of the principles, frankly, as Mr. Shankar was saying, under the law of contract itself, as well as the observations already made in the judgment of Lalit Kumar. I don't see how those two can fit. I think they are incongruous, frankly. So I think that this will be revisited eventually by whether it's by eventually by the Supreme Court. So, but I think it still has to go through rounds of litigation before it comes to that, happen over time and get settled once and for being conflicting, references and, different issues coming up and conflicting in terms of conflicting judgments of high courts or even, different benches of the Supreme Court. So it's better that, things are settled in a more, comprehensive way.
Okay. One last comment before we end from Manmeet Singh. Lenders and their right to invoke personal guarantee. That is the question everybody is talking about now. Could you give your 2 minutes on this one?
Yeah, as far as lenders are concerned, I think notwithstanding this judgment of DRT, lenders are going to go ahead and keep invoking and keep filing, right? Unless there is a stay, because what is done by Ahmedabad DRT is not binding on other jurisdictions and other courts and other tribunals. So I don't think for the time being it impacts, other than maybe for the purposes of Ahmedabad DRT. So lenders will stay the course. I don't see any change in approach in the short term, at least.
You don't see it changing in?
Yes, I see no reason why lenders would modify their approach. This judgment is likely to be carried in appeal. And given the fundamental question of law, there is a likelihood that it may even get stayed. So I don't think it will impact the approach of lenders generally at the time, for the time being.
And Shravant, what do you think on this?
I completely agree with what Manmeet Singh is saying. So it will definitely change the entire way we are approaching things because what Ahmedabad DRT's judgment is subject to adjudication on the appellate court. So what Manmeet is saying is completely true.
Okay. Tahira Karanjawala?
Yes, I completely agree. I think it will get revisited eventually. And I don't see how it's congruent. I don't think it fits with the general law of the land as of now. And that's my own view, that I think it will get eventually reconsidered and may even get stayed in the interim.
Okay. Thank you so much. It was an interesting discussion today. We will need to revisit this issue as, of course, this gets appealed in the higher courts. We all keenly look forward to see what happens. I would like to thank Manmeet Singh, partner, Seraphin Partners, Tahira Karanjawala from Karanjawala and Company, Advocate Shravan Shankar. Appreciate your joining us, and thank you viewers for tuning in. Thank you so very much.
Tarun.
Thanks.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.